Hello, I'm Erin Doucette. I'm from Prevention Link. We are a essentially innovative disability prevention program. We're funded by the Ministry of Labour in Ontario through the Prevention Office and administered by the Ontario Federation of Labour. Essentially, we provide training to union representatives, legal professionals, and worker advocates predominantly in the area of workers' compensation law and accommodation law. We also provide more broad-based rights outreach to vulnerable workers, so anything to do with human rights, employment standards, occupational health and safety. But essentially, what I'm here to talk to you about today and what we're very excited about is our joint return to work initiatives. And I think it's interesting because some key themes, I have to say, speaking towards the end of the day maybe has its cons because people are fading and, you know, maybe you had too much cake or something like that. But I've had the benefit of hearing lots of really great, wonderful ideas, and I hope to sort of maybe weave those into my presentation. So we're on the panel that talks about innovation, and that's been touched upon quite nicely by my fellow panelists, but I think that word is a word that can be, as much as it's a positive word, it can be somewhat intimidating when we think about that. And I think what we're hearing is that sometimes it doesn't have to be that way, and that there can be often very simple solutions that are often right in front of us. It's just a matter of asking the right people and bringing the right people to the table to talk about that, and that's what's so key about joint return to work. So we're talking about bringing together employer, and union leadership, but also making sure to include the workers' voice at the table. So if it's not too late in the day and you can entertain me in like a small little sort of exercise that I think demonstrates the whole concept of disability prevention, and it's I realize I'm sort of have the benefit of being in a very conscious and aware and sensitive crowd, so I often do this with sort of different crowds, but it's an example that's a bit impactful for me because it deals with my impairment, and I have a very high prescription glasses. Which one do I go to? Thank you. So I'm just going to ask anyone who is wearing corrective lenses, if you don't mind taking them off and just thinking about how that impacts your ability to fully participate in the conference right now. Can you see your notes in front of you? Can you read the screen? I can't see anything. Like, you all could have left by now, and like I don't even know, but I hear you, so there you are. And then we put them back on, and now we can fully participate in the conference, and we can see our notes, we can see my smiling face, and you can see the screen. And this is essentially, in a nutshell, disability prevention. My impairment remains, but I don't essentially have that disability anymore because I'm able to fully participate and be a part of the conference. And that's a theme that I'm hearing a lot through our roundtable discussions and the discussions today. And again, just that notion of looking for solutions that are often right in front of us, and the best way to achieve that is through collaboration. And that's why, again, our initiatives are to do with joint return to work. So again, we do function more essentially in the realm where we're dealing with unionized workplaces. And obviously, many of you can appreciate that there are a lot more benefits to that and protections when workers have a collective agreement that helps protect their rights. So what happens, though, and I'll also add some information too. So in my experience, prior to being with Prevention Link, I was with the Office of the Worker Advisor, which is an Ontario agency of the Ministry of Labour, and we provide a free legal service to non-unionized injured workers. So I have had a lot of experience dealing with workers who don't have the benefit of a union, and often seeing them so many years after the fact and trying to clean up where return to work went wrong because there wasn't that the representatives getting in there in the initial stages to help with identifying suitable accommodations, working with their employer, and to get them back to work. Because the longer that time goes on, the more entrenched a disability becomes, and the more difficult process it is to get them back into the workplace. So For us at Prevention Link, basically what our key tenet of our services is around education of both employer and union leadership, and to get them to the table and develop return to work policies and programs, develop the language so that there can be a successful and seamless program that's modeled at the top. And we've heard a lot about culture, shifting the culture and shifting the concept, but we need to have that have a trickle-down effect, so it's going right through the workplace, because often that's where the problem is. There may be a really great return-to-work plan, but if the workers don't know about it or don't know how to access it, or maybe they think it's only for occupational injuries and diseases as opposed to non-occupational. So an effective plan essentially is a plan that everyone's aware of, they know how to access it, and that there's appropriate training and guidelines in the workplace. And then again, in a unionized workplace, there's the benefit of negotiating that into the collective agreement. So you can give something like that a lot of teeth. You can also have a separate sort of more living document that's a return to work plan that sort of exists outside of the collective agreement, and that way you don't have to necessarily always wait for negotiations to come up. It's sort of more of a living, fluid document. And so, again, back to our creative solutions. So again, the biggest problem that we're finding with dealing with return to work and identifying accommodations when we go into workplaces is just that the workplace parties don't often know or not often aware of what their obligations are and their legal liabilities. And that applies to all the workplace parties. So it's not just, the onus isn't just on the employer. The onus is also on the worker. And again, we've had the issue of disclosure come up, so it's not about revealing what your diagnosis is, but there are significant case law that identify that workers do need to at least identify their limitations and restrictions. And then there's onus on the union as well to, as far as their duty to represent and their duty to accommodate. So again, and I know we've talked about the term reasonable accommodation and moving away from that, but we again function in the confines of the law, and so we are dealing with the law, and this is the threshold that has to be met by employers. There you go. And with regards to the union's responsibility as well. So we find that when we do our information sessions, this is sort of the point where a lot of people really sit up and listen, because there's sometimes often not that awareness about the legal responsibility that fall on the shoulders of both of the workplace parties. And we've heard too, even just the concept of rights-based, that term was brought up earlier in one of the earlier panels. And again, I think that's also key to keep in mind in this context as well, is that an injured worker or a disabled worker has the right to representative, and although the duty to represent doesn't apply to comp cases in the sense of appeals, but it does apply to return to work. So the union has to be at the table when dealing with return to work. And this is just highlighting, because everyone loves a little bit of case law, right? So a leading case, the Renaud case, which actually doesn't deal with disability accommodation, but this is a leading case as far as emphasizing the union's duty to accommodate. Moving along. And then I'll just touch really briefly here on the link with prevention, because obviously that's key. And when you do, as far as the duty to accommodate to the threshold of undue hardship, when you do the procedural aspect of the duty to accommodate, which is essentially the investigation, that's often where a lot of hazards can be identified that although you might be dealing with one particular injured worker, when you go and look at some more broad-based hazards in the workplace, and by alleviating those, then you're actually achieving prevention, because there's that opportunity to make the workplace more safe for the entire workforce, and not just that particular injured worker. So that's part of the process where we can really make that link with return to work and prevention. And this is essentially, sorry, I'm not really good on the PowerPoint there. So I'll just wrap it up really quickly. So this is essentially our return to work services. So I am obviously going to give a bit of a plug for our services, but what we go in, we essentially would want union and employer buy-in. We do a situational assessment, which is perception-based, and the point of that is to identify gaps that we can help. We produce a confidential report, and then it's at that point that the leadership would essentially engage our services. And it can be anything from developing policy and programs, training, and essentially we work all the way to the bottom one, which is to facilitate the program and essentially leave the workplace parties in a self-sufficient way, but we can always come back and help with evaluation. So, yeah, all done. I'm wrapping up, and then there we go. Thank you. Excellent.